thank you everybody for joining us here at the annual Nexus event here in Adelaide. Thanks for taking time out of your busy schedule to be with us today. My name's Simon Wilkins. I'm the Managing Director for LexisNexis Australia, and I'll be the facilitator today for this panel and group discussion titled Legal Frontiers, AI to Ethics. This is the 4th year in a row that we've run an event series such as this with the aim of really facilitating discussion on a number of topics in the legal services community. This year we'll look to uncover perspectives on the current impacts of technology, including AI, on a rapidly changing legal industry and how this may impact the future. And indeed in our organisation we talk about how legal tech is changing our space more now, and how it will change things in the next 3 years will be more than it's changed things in the last 30. Many of you will know LexisNexis already, but please indulge me to tell you a little bit about ourselves. We've been in business now in one shape or form globally for over 200 years and have a long-standing history of innovation within the legal industry. Traditionally, you'll know us as a provider of legal content, but now we're fast evolving into an information analytics and decision tools business. And indeed, I've just returned from a senior leadership conference in Menlo Park, where we have what we believe is a real established place there, sitting next to legal startups and entrepreneurs alike, who really sit at the bleeding edge of what is going on in this space. As time has gone by, we've seen the way in which lawyers utilize content has changed rapidly. First, the obvious transition from hard copy to digital and online forms, but now we're seeing some other interesting changes and more complex demands take shape that offer what we believe are quite interesting possibilities. In the US, our organisation has acquired businesses such as Lex Machina, Ravel Law and IntelliGize, which help us extract quantitative insights from huge data sets to provide lawyers with the information they need to make decisions faster and more effectively than ever before. And in Australia, we've launched solutions such as the High Court Analyzer or Court of Appeal Analyzer, which are off-the-shelf data visualization and analytics solutions. But we also see the demand for more customized analytics solutions fast emerging that really harness the power of our Australian content or data to quickly surface connections and information for intelligence purposes, litigation or commercial insights that would otherwise have taken hours and hours to uncover. Some of you will know the Lexis Advanced platform that surfaces more data, actually a petabyte of data. That's more than everything that's on Wikipedia, and this is enhanced regularly as every good software platform should be, with incremental improvements delivered every 6 weeks. These enhancements are supported by an ever-growing army of agile UX specialists, data engineers and developers, and the platform itself uses machine learning and natural language processing to analyze the content you search for and surface it based on semantic similarity, meaning the information you need is more accessible and with you faster and more easily than ever before. But we're just one player in this space, and again in an area that we see changing fast. There are countless legal startups, for example, and firms and organizations of all sizes and shapes are having impact. Indeed, there were 787 legal startups in 2018, and 36 of those were in Australia, and that compares to only 17 globally in 2010. So you can see it's an exciting space right now, and we're very excited to be part of the conversation. And I'm looking forward today to what undoubtedly I think will be a fascinating hour and 15 minutes or so, with opinions from our panelists, but also obviously, hopefully from you, the audience as well. So before we get underway, a little bit of housekeeping. The toilets, if you don't already know, are out there to the left. There is Wi-Fi available here. It's a little tricky to get on, but if you do need Wi-Fi, please raise your hand. We'll make sure we get the details to you. Otherwise, please use 4G if you can, because we do have some things we'd like you to contribute to as we go through the afternoon. And you can also use Twitter if you want to. And we're using the Twitter hashtag AI2Ethics18, which I think you can see at the bottom of the slide. So let's get on with it. First, I'd just like to introduce our panelists. To my left here is Melissa de Zwart, who's the Dean of Law at Adelaide Law School. Melissa joined academia from legal practice in 1996. teaching in the undergraduate and postgraduate programs at the law school, Monash University, where she developed several new courses, including internet law and technology contracts. Prior to this, she was legal manager at CSIRO, where she developed an interest in laws affecting technology and innovation, and in particular, regulation of the online environment. Her research interests include copyright, surveillance, online communities, and space law. Next to Melissa is Luke Dale. Luke is a partner at HWL Ebsworth. Luke practices in the areas of corporate and commercial law, with a particular focus on intellectual property law and brand protection, technology law, media and entertainment law, and trade practices issues. Luke is recognised in Best Lawyers Australia for commercial law and intellectual property law, and additionally Luke has been recognised as the Intellectual Property Law Lawyer of the Year for Adelaide. Next to Luke is Morry Bales. Morry Bales is the President at the Law Council of Australia. And Morry is also the Managing Partner at the firm Tyndall Gask Bentley and has been there for 16 years, overseeing its significant expansion in that time into Western Australia and the Northern Territory. Morry's firm is the largest family law and plaintiff practice in South Australia, also practicing in the areas of succession, workplace and criminal law. And Morry is a member of the Australia Institute of Company Directors and was the 2013 recipient of the Brian Withers Award for services to the legal profession in South Australia. And in his spare time, he spends publishing a regular column about law and law-related issues in South Australia. And then finally, on the left there, we have Darren Kruse, who is the principal at Kruse Legal. As one of the very few lawyers with a deep technical background in IT networking, cyber law, and cyber security, Darren is uniquely positioned to assist clients in bridging the divide between the cyber and legal worlds. Prior to becoming a lawyer in 2008, Darren worked for almost 15 years in information technology. And his international experience working in the UK, South Africa, and Malaysia allows his clients to leverage one of the very few IT lawyers in Adelaide with a proven cyber security background. Please join me in welcoming the panel. All right, so I'd like to get the discussion off by playing a quick video, fingers crossed.
This has something to do with my kids.
Look what happens to your son.
My son? God, he looks just like me. Within 2 hours of his arrest, Martin McFly Jr. was tried, convicted, and sentenced to 15 years in the state penitentiary? Within 2 hours?
The justice system works swiftly in the future nowadays. Abolish all lawyers.
Oh, this is heavy.
Or it gets worse. Next week, the daughter attempts to break him out of jail. She gets sentenced for 20 years.
My daughter? Wait, I haven't taught.
So back in 1989, when they made Back to the Future 2, Doc Brown was referencing a world in 2015 where there were no more lawyers, but there were hoverboards, if you remember the movie. But in 2018, I think we can agree lawyers are far from being abolished. But as AI and automation make inroads into legal services, perhaps we should be thinking more about the way lawyers work and how that's going to change, that is really driving the future. Because with this new opportunity comes added responsibility. Ethical questions related to the growing use of technology abound. As tech becomes more complex, so too will its relationship with people, and new rules may need to be developed for this new frontier. So in the next hour or so, we're going to explore a number of key areas in this space, including things like data protection and algorithmic bias. We've got a lot of ground to cover, and I'm sure we're only going to scratch the surface of some of this discussion, but we'll endeavour to do our presenters and the topics justice, and I'll make sure we get finished on time. So to get our discussion underway, a few points to note first. We're going to be live polling during our sessions this afternoon, and that does mean this is where you get to use your 4G, I hope, that you'll have. So on your mobile phones, go to a browser and enter in that address. That's pollev.com/Lexus-AUS. Panelists, you don't need to do this, but you can if you want to, be my guests. And that will allow us as we go to ask questions of you, the audience, and see responses immediately. You don't need to log in. If you're prompted to enter a screen name, just ignore that. You can choose to skip that and obviously remain anonymous. And as we want our discussion to be really robust today, we may be going to some of these responses as we see them. And the floor is indeed open to questions at any point, but I will be carving out 15 minutes at the end of the session for questions. So it might be easiest for you to lead your questions to that point. Okay, so let's get going. The first thing we're going to do is just really look at the reality of young lawyers and what's happening for the young and lawyers coming into the profession, and really what is the kind of 5 to 10 year view on that space. And it is an interesting topic. It's something which is talked about a lot, but it's always a great one to start off with in terms of just really warming us up. So I'd like to get some remarks from all the panelists on this one, but I'll start first with you, Melissa, if I may. Let's just think about universities and how they're preparing for the next generation of lawyers. Do you believe they're really equipping those next generation of lawyers with the right skills?
Well, I think I would be doing myself out of a job if I said no to that.
Okay.
So I'm going to answer that very carefully, I think we are equipping the next generation of lawyers. I think what is very difficult is to know what is the next generation of lawyers. Because we're in such a period of rapid change, I don't think you can ever say that we're going to be able to cover off, all the skills and every individual piece of knowledge. But remembering what we're doing is we are giving people the foundations and the fundamentals and the skill areas that they will need. I mean, when we started in practice, we didn't know all of the knowledge areas, but we had the capacities to begin to emerge. So, we're not producing a fully fledged lawyer at the end of the law degree. We're giving them the foundations and the skills that they need. And frankly, from my observations, the graduates that we're turning out at the moment are, certainly, superior graduates to what they were when I was graduating in terms of their work ethic, their skill level, the experiences that they have. So I think the answer is yes to that.
Thanks, Melissa. I may go to Darren there at the end with the same question. Darren, what are your thoughts on this?
I'm seeing, I've had a couple of graduates come to me from the universities, and I've been uniformly impressed with how well they're presented. They are technologically literate, able to pick up all the technology that our office has and instantly, really without me having to teach them. And it's assumed knowledge these days. That's how they come out of university, with the ability to drive and use all the technology. The law, is taking us red. So really, what we're searching for when we get graduates are the soft people skills, their work ethics, and the intangibles that you can't really point to a score on a academic transcript for. So I'm pretty happy with what's coming out of the law schools at the moment. Probably it.
Thanks, Darren. And Luke, I saw you nodding along as Melissa was talking there. What's your experience?
I can say that I wouldn't have got a job if I was graduating now. The standard is incredibly high. Luckily, when I started practice, it coincided with Google being widely available. So I literally was able to type in, what is stamp duty? Got me rather than spending a lot of time in the library, so I was very lucky in that regard. It was a couple of years earlier, I would have been stuffed. But certainly, the quality has improved. The sort of roundedness of the candidates has improved as well. Everyone acknowledges they have to add a lot of strengths to their bodies, which also makes them a better sort of rounded person and able to sort of slot in much more easily than if they've just focused on their academics all the way through. I can say, as a partner of one of the biggest law firms in the country, that it's been a real focus in the short term for our firm to hire more graduates, because we acknowledge that we need to be training up the next generation and making sure that we're not hollowing out. And I think that's reflected in all the big firms around the country. So that's a positive thing, I think, for the profession and also for the graduates.
Great, thanks, Luke. And Morry, finally to you, what are your thoughts about this and kind of industry expectations in this regard?
I agree with the remarks. Broadly speaking, we've got some very, very good and able graduates. I'm interested in other people's thoughts, though. The ability to use ordinary current technology is not in question. I'm not as convinced that graduates coming out of law school are necessarily equipped with skills that might lead them into the remainder of the century to stay ahead of the technology curve. And I think that there's obviously some efforts by some law schools to squarely address that.
Okay. So if we think about staying ahead of that technology curve, as you put it there, Morry, what do we believe that technology curve kind of looks like, and maybe that the notion of what those most disruptive or those technologies that we would anticipate that you know new legal practitioners would just know or would just would need to grapple with. What do you think those technologies might be?
Well, there are probably people better at this table to answer that. I'm not a technologist per se, and my areas of law, as you learned, give that away. But from the position of the Law Council of Australia, we've been examining the issue of the future of the law, the future of the professional services more broadly. And really there seems to be a significant division of opinion about what's going to happen. In relation to AI, which is not defined per se, but encapsulates, I think in use at the moment, a narrow AI, which is either learned logic or different types of application. What's required is that people who come out of law schools are going to be expected to be able to use that type of application. When it comes to general AI, or the concept that the algorithm could have human-like thinking, it seems that the jury's out in terms of whether that will in fact occur, and if it does, when it will occur. And the predictions seem to be that if it occurs, it'll be within the latter half of the century, perhaps 2030 to 2100 is what the Law Council has divined from its literary research.
Okay, thank you. Darren.
Simon, I'd like to throw the question back at you. Because you, LexisNexis successfully...
Taking our jobs.
Lexis successfully seeds a generation of lawyers by giving them access to Casebase, which probably cut off when I left university. But my question would be, will you be seeding the generation of lawyers with access to the AI tools, so that when they come to us, they've already had 3 or 4 years of access to these tools, because clearly that would be in your commercial best interest, I'd imagine.
Thank you for that, Darren. That was a gift that you threw. Yeah, I mean, certainly our view is that our organisation sees the opportunity to further augment and improve our solutions by investing in AI, and that's what we're doing. And certainly we would see that as being something that we would want the student community to be exposed to, for lots of different reasons. And again, our view there, it really is that, as I say, I think that the space is changing fast. So if we don't do that, actually we're not relevant. And that's really what it's about, you know, that drive to stay relevant, stay part of this changing world that we're in, and I think that we're going to explore a little bit in the next hour or so. But for sure, we would see the student community, you know, new lawyers in the future being a community we need to serve in this regard as well. So and on that, I mean, you know, we're a data and an information analytics provider, but there are plenty of other technologies in this space too. I mean, there's workforce automation, there's blockchain, you know, again. So I just want to open that up just to keep us moving in the discussion. Luke, I don't know whether you have a view on this. What are these disruptions coming, do you think, in the industry that we just need to, you know, get to grips with?
Well, I'm a technology evangelist. I find it all really cool when I talk about emerging technologies and how they intersect with the law all the time. But I have to say, the more I do it, the more cynical I'm becoming, because I think in the 10 years that I've been talking about innovation internally in the context of managing a law firm and talking about what's going to be coming and how it might be changing things, nothing's actually changed yet at all. At the moment I'm inside one of the biggest firms in the country and nothing's changed. and we're still running a traditional law firm model, and I think our competitors are as well. There's stuff around the edges, sure, but nothing's actually fundamentally changing things. It's the same when I started talking about 3D printing 5 years ago. I was really excited, and I said it's going to change the world, it's the next industrial revolution, and nothing's changed. So I was a bit embarrassed about that. Talking about Bitcoin is going to change the world, blockchain, smart contracts, it's really exciting, and then the market fell out of Bitcoin and now no one talks about it anymore. So I think I'm guilty as much as a lot of people sort of getting excited about the next new thing, and it probably takes a lot longer for it to actually work the kinks out and figure it out where the real place is for it. So yeah, it's really nothing's changed yet for me, but I constantly read everything and see what people are saying. I wait for the first autonomous car to go past me and I'll be excited.
Okay, thank you. All right, so let's move on. We're going to look at a little bit at this idea of the professional responsibility of the tech-driven lawyer now, and you know, technology in this space is definitely there to stay in one way, shape, or form, even though it might not be quite as impactful as is anticipated. But it's interesting, in 2013, the American Bar Association revised the ABA model rules of conduct, professional conduct, to state that lawyers must be tech savvy in order to provide a competent representation to a client. And we don't have similar requirements in Australia around that, but the question remains, if lawyers are using AI, or they're using analytics or other kind of complex technology to assist, do they have a responsibility? Is there a professional responsibility to understand what criteria is being used by the technology, so they can assess whether the tech decisions are sound or where they come from? And we're going to open this up to the audience and see if we can live poll on this. There we go, straight away. So the question here is, do lawyers have a professional responsibility to understand the tech they use? And as you respond to that, unless there's only one person
The
who has this
true
word.
lawyer answer would be maybe.
Yeah, well, let's see. Maybe is. There it is. There straight away it comes in. So whilst these questions get populated, I might go to you first on this, Melissa, for review. So do lawyers have a responsibility to understand the tech?
So I'm going to take issue with your question because I'm a lawyer, right?
Yeah.
I agree with you about the maybe, but do lawyers have a professional responsibility to understand the technology they use? It depends. It depends what you mean by the technology they use. Do they have a professional responsibility to understand the technology that they advise with respect to? I think would be another issue as well. So I think an answer to this would be something like the whole sort of Robo debt debacle. So you had the appointment, the transferring of debt by Centrelink, where decisions were made, and people received notices that were incorrect, which then took a long time to be corrected, that caused a whole lot of flow-on social effects to people who were certainly the people who were probably least equipped, emotionally, socially, financially, to deal with that kind of pressure. And who ends up dealing with the mess? It's lawyers. It's lawyers who have to go in and say, well, how were these decisions made? What were the inputs that were made that led to this? So, the problem is created because you have, sort of techno-utopianism. And of course, I'm also a complete, technophile. It is great, but if you are relying upon it to make decisions about people, then people need to understand what the underpinnings of those decisions are. So we have a professional responsibility to advise with respect to tech that decisions are being made by. So if we're using a database that says, I'm going to predict to you, your client's chances of success in this trademark infringement matter. So there's been a lot of work done in the US that is highly accurate in terms of predicting outcomes in sort of trademark infringement cases or copyright cases. If you're going to be advising your client on the basis that you need to know what the questions that have been put into that generate the outcome. Do they have a professional responsibility to understand how this works? No, I don't think they do. So I think there's sort of a difference. Do they have to understand how to program a computer? Probably in most instances not, but if you are the sort of lawyer who advises in that industry, then yes, you do. So, you know, I feel like I have a professional responsibility to understand how the technology that I work in, how that works. So I need to know how the internet works, and my students who are working in this area need to know how the internet works, but that doesn't mean that the students who are going to be practicing in another area will need to know. So it depends.
Okay, thanks, Vanessa. Morry, your thoughts on this?
So, just a personal comment, I'm not in favour of conduct rules that require that type of level of just prescription. The interesting analysis that I've got access to is about what different firms are doing, which in part picks up what Luke was saying in answer to the earlier question. Here, firms that have a turnover of over 20 million are described as successful in Australia. 73% use or plan to use decision dashboards, 54% data mining, 45% predictive analytics. Now, obviously, if you only practice in that firm, then essentially you have an ethical obligation to understand what you're using, because that is part and parcel of your ethical obligation to the record and to your client. But in successful small firms, turnover of less than 4 million, the uptake of new technologies was not reported as a trend. In other words, there's specialist practitioners that are working in a particular area and they're relying on their specialty to be able to practice. So I don't think that it's a one-size-fits-all, and it probably depends on your client, whether you're working for Telstra or a small business. And I wonder whether the way in which to deal with this type of question, because as we've done in other areas of law, which is accreditation. So if you want to see a practitioner who has a particular skill set, then that practitioner can accredit themselves. So you don't prevent people from practicing, but the consumer is entitled to have a better choice by picking an accredited person if they want to technology accredited for them.
Thanks, Morry. Darren or Luke, do you want to chime in on this one?
So I think whenever you're using a technology to deliver a service to the general public who rely on the integrity of that advice and quality of that advice to make pretty major decisions in their life, the practitioners are under a pretty strict obligation to understand the limitations of that technology, what it can do, what it can't do, where the gaps are. For example, you're asking a question for a legal opinion of an AI. Are the ethical rules built into it? Are they not built into it? The AI doesn't owe a duty of care to anyone. The lawyer does. The lawyer is bound by professional conduct rules. The lawyer is bound by Australian consumer law to the services with due care and skill. The AI is not bound by any of that. So if you don't understand the limitation of the technology you're driving, you shouldn't be driving it. And I think that goes from buses to AI. You don't want to underestimate the stopping distance of the bus. You don't want to, if you're driving it, you don't want to be let loose on the public without with technology that may be beyond your understanding. I'm not sure accreditation is the right way to go, but I think disclosure certainly is. And if you're giving advice that's based in part or in whole on what has come out of an AI, then there should be disclosure. And I think that is pretty, we can probably get onto that a bit more later with chatbots, but I think that's a pretty dodgy area at the moment where there isn't always proper disclosure as to is it a human or is it an AI. And that's going to be increasingly unclear to the punters, and I'll share the link later, because if you watch Watson,
Just speak up.
if you listen to Watson, IBM's Watson AI playing Jeopardy, it understands natural language. And then if you go a little bit further, that's on YouTube, and if you go a little bit further, Google recently did a technology demonstration where they were making an appointment with a hairdresser, and there was a lot of outrage over it because the human on the other end was completely fooled by all the nuances and imperfections of human language, particularly the second phone call, which didn't go according to script. Humans had no idea they were talking to an AI. And it's coming that you'll be able to phone a Robo lawyer, and the question would be whether disclosure, because you won't be able to tell the difference.
The question for me also plays out in another way, and that is not whether you're able to use the technology, but whether ultimately one day, for instance, if lawyers have available to them augmented intelligence like that just described, and one lot of lawyers use it and one doesn't, is there some sort of ethical obligation to in fact acquaint yourself with the ability to use it, because otherwise your client is not getting the breadth of advice that augmented intelligence may offer a professional, including a doctor.
I would add, obviously, LexisNexis AI products are excellent, but I think it would be a very brave lawyer to give advice based solely on the output of something like that sort of product.
Yeah, I fully understand that. In fact, let's jump into the next question, because I think Darren touched on this idea of chatbots, and we can just explore a little bit more. So, my understanding of this space right now is that chatbots are there to provide legal information rather than legal advice. So it's their information providers. Darren's example of the hairdresser appointment, I've seen that too, and it's quite amazing. So this notion of nuance and context and kind of emotional reasoning or acknowledgement, the technology is able to do this. So the question really is, can we imagine a world where a chatbot could administer legal advice, and we can see that kind of working in reality. Again, I don't know whether any of the panelists wants to jump in on this particular question. Luke, you look like you have something to say.
I was just going to ask what the dividing line is between providing legal information and legal advice. Because if a chatbot gets asked, how do you register a trademark? And the chatbot says, well, under the Trademarks Act, Section 20 says this. That's legal advice. It's also just providing legal information. So I don't know how people reconcile that.
Well, there are cases about it. There was a West Australian case called Wills, where it's an old case, but the principle remains, where non-lawyers were providing standard clauses to a will, and their error was to assist the client or the consumer to pull the clauses together, and that was regarded as legal practice. So it's fairly clear that we need to draw a distinction at this stage in terms of our regulation as to what is the mere provision of information and what is the provision of advice. Because even taking instructions from someone in this state under Section 21 of the Legal Practitioners Act is legal practice.
So if you ask a chatbot something, are you giving it instructions?
Well, it's a really interesting question, because this is learned logic, obviously. So the supposed notion attached to it and so forth is nothing but learned logic. So you're just talking to a machine. And here, I think at the moment in Australia, if that was dispensing advice, other than under the direct control of the legal practitioner, you'd have a problem. But it begs the question as to what we're going to do with our regulation. Because there's going to be unregulated service providers that enter the market to provide legal advice, and it's just a reality. So we've got to accept the fact that our legislators at some stage may need to legislate to regulate unregulated services so that we can protect consumers and keep information asymmetry the same. And it's an issue of what that would then look like.
I think that Section 21 is primarily there to protect the public, so that cynically it's also viewed as the protection of the profession, but primarily I think it does protect the public, because people make very big decisions in their lives based on legal advice. The motion picture industry has been very successful in having the Commonwealth government shut down rogue websites that infiltrate into or allow into Australian copyright material, Pirate Bay, etc. They're blocked, and there's legislation about that. There may come a day when applying the same principle to sites that purport to offer legal advice from the Philippines about the Australian taxation law for $20, ask any question you like. Just put your PayPal or Visa card in here. May well also be regulated in the interest of protecting the public, but that's going to require a national approach to what is the profession of law, what is information, what is advice, and the Law Council of Australia, I think, has got a pretty strong role to play there.
Yeah, agreed. We're not regulating in the sense that law societies and bars do, but when it comes to the regulation of unregulated service providers, that's a matter for lawmakers and policymakers and parliaments.
Fascinating area. Melissa, I don't know whether you have a view in this.
Well, I was just going to add something about the question of what the role of the lawyer is, and equating it with essentially just providing information. So I think it was many years ago that Bill Gates notoriously, in an interview said, well, we don't need universities anymore because now we've got the internet, we've got access to endless amounts of information. And I think he retracted that only a couple of years ago, recognising that it was all very well having endless amounts of information, but if you can't identify which bit of that information actually applies to you, then all of that information is virtually useless. And I think it comes down to characterising largely to what it is that lawyers actually do. And we're not just a conduit for accessing pieces of information. We're not just the same as a search service or a chatbot. There's information, there's service, there's quality, there's assessment, there's all those individual things that go along with it. And I think sometimes, I agree with everything the panel has said. Sometimes we're almost, I think, guilty of sort of underplaying exactly what it is that we provide. So I think we need to be really careful about sort of even saying that information is what we do. It's a part, identifying the right bit of information. And it's struck me too, that I remember, I am old enough to remember the days when you used to have to go into the library at the law firm and ask to be allowed to access an unreported judgment or an overseas judgment. A little printer would whir on the desk and the librarian would stand there and say that this was $20 per page and hope that it was really worth you accessing that. And we now we now have the time where we can access judgments from the US. We can access judgments from countries all over the world, which is fabulous. And I think it has led to an improvement in the law. It's improved jurisprudence. We have great information exchange worldwide. But the big danger of that, of course, is the Googler, who Googles a legal term and gets some piece of Kentucky law and thinks that's going to apply to them. So
I'll give you the classic example, because when I googled stamp duty, I knew that it didn't mean how to successfully post a letter in the postal system.
yeah.
Thanks. Okay, yeah. Let's keep moving, because I appreciate we could keep in this space for some time, but there's a couple of other areas I want to make sure we do touch on, and one of those areas, which again is a significant, I think, area to consider in terms of the way that technology works and benefits or doesn't, is this area of data privacy. So, it's a topic, of course, that's got an enormous amount of media coverage recently. Everybody, of course, will remember Cambridge Analytica. But, of course, also the media coverage in areas such as my health record, for example. And opting in or opting out of that. And it shows, how frequently people are aware or maybe unaware of how data is stored on them and how it's being used. And this idea of the technology and AI in particular, machine learning technologies, they need data in order to provide services, and that sometimes can be a friend and sometimes it can be a foe. Luke, I might go to you first on this one. I mean, when you think about this idea of consent to data and what people have explicit knowledge of in terms of how that data is being used, what are your thoughts about this?
It's an incredibly feeble area at the moment. In the area that I'm in the firm, we advise a lot of clients on privacy, and certainly the GDPR, when it kicked in earlier this year, threw up a lot of concerns for clients. It's sort of died down now, and people realise no one's actually getting prosecuted yet, but it will just take the first person to get prosecuted for everyone to freak out again. And the notifiable data breach response requirements that came into effect earlier this year in Australia as well sort of piqued everyone's interest, and I think it's clear that this area is getting more and more heavily regulated, both in Australia but also the Western world. Europe's leading the way, but people are waking up to the fact that their personal information is a currency. They shouldn't just be giving away for free, and also recognising that there can be really adverse impacts on it potentially, depending on how that information is being used. The flip side of that is also, I think, people shouldn't get too hung up about data per se. constantly tell people you can't own pure data, you can't own information. It is information, it's bare facts. So people can do with that what they will, subject to any contractual obligations or otherwise. It's only if it constitutes personally identifiable information that you step into the regulatory regime. So if we're talking about de-identified information, go for your life as far as I'm concerned. But yeah, if it's able to be drilled down to identifying particular individuals, then you need to be very careful, and I suspect at the moment the government's talking about rolling out a new consumer data right that banks are going to have to be compliant with, and potentially other industries. So it's open for feedback at the moment. I'm pretty sure that's going to go ahead, assuming we still have a functioning federal government. So I think it's just going to keep changing in this space, and it's going to get harder and harder for private enterprise to use data as they want to.
Yeah, we have a live poll question about the GDPR actually, which we'll just open up as we go to the next question here. Really, this idea of your comment there, Luke, was an interesting one about feeble policies or feeble protections in this space right now. And so our question is, do we need something like the GDPR or something like that locally? Morry, do you have a comment?
Yeah, well, I think we do, and I agree with Luke. Privacy as a concept in Australia and in states and territories is a nebulous one to an extent versus some other jurisdictions. I've seen it in a completely different context, and that is in relation to national security laws that the Federal Parliament has introduced, and for instance, the Law Council of Australia gave a submission and gave evidence in relation to a bill in part relating to facial recognition. And it's a very different world when, as distinct from, say, the police lineup, where you might be asked to participate as a volunteer, to having CCTV surveilling our streets, our beaches, our public areas and so forth, without our knowledge necessarily using our facial recognition for what was intended to be a good proper purpose to stop serious crime and terrorism, but discovering in that bill that it could be provided to states and territories, and in certain circumstances if they met the right criteria, councils and private companies, and you realise that what it's going to be used for is probably the provision of services and so forth. Marry that up with something that's unlikely to happen in Australia but is in China, and that is social profiling and preventing people from being provided with services if they don't obey traffic rules and so forth and other regulations, and we're going to a very dark place, and that's to do with our civil rights and our privacy.
Thanks, Morry. Darren or Melissa, do you have anything to add on this?
Only that there just needs to be kept in mind a very clear distinction between what is public data and what is private data. Public data is, you've been in a case, you've had judgment against you, your name's there. The fact that walking on the beach, your face is out there, that's public data. What use is made of it is really open slated. The private data is the data that every one of you has leaked today by having your phone on, and you've leaked your location to Google, or if you've got an Android machine, they know where you are. That's your private data, but it's been made available to them. You've got some control over it, but most of us don't bother.
And the NSA has activated the microphone function, so I was listening to everything as well.
And also your web history, every website you've surfed to, every SMS you've sent. I think it was George Brandis was the Attorney General at the time, I'm not sure who it is now. Christian Porter, thank you. If you don't want Christian Porter having a record of who you're texting or what websites you're going, use end-to-end encryption and WhatsApp or Telegram. So you've got but people need to be aware of this and keep in mind that some of this private data that you think is private to you.
And when the politicians are using WhatsApp themselves, that probably gives you a clear indication.
Yeah, but you can't stop the screenshot.
Can I add? I think I'm actually more paranoid than you, though. I agree with you about the difference between the personal and the open data, but there's there's increasingly a push to, particularly by governments, I think, to commercialise, open data sets. So, we've had again, the evangelical days of, the great things that you can do with open source data. And one of the earliest things was the big map that was done of Australia with where all the public toilets are. Fantastic project. I think that's a great public service. So everybody agrees about that. But, when you have, open data sets sort of coming out of, say, the health industry, and there was a really fascinating / scary project that's come out of some academics at Melbourne University who looked at whether you could re-identify, de-identify data in open data sets. And they said that you can de-identify data, and the subject that they looked at was women who had babies, and they could take 3 data points from the open data sets that were released by the government, and they could re-identify who those individuals were. So we tend to bandy around terms like de-identification and believe that we are living under some, great mantle of protection. And I just don't think that we are there yet with the de-identification. So I think I should sort of add to that too. I'm kind of less worried about the NSA now having access to my data than a business like Cambridge Analytica. I mean, the fact that all 4 of us sitting here at the table could be getting a different stream of supposed, news information, and the way in which that can be used to manipulate what people think about things. I think we are actually really having to start unpack these ethical issues about what use is being made of data that has either been gathered by governments in these sort of big de-identified so-called data sets, but also the information that we ourselves willingly give away. So, I'm going to say consent, because that's just like a whole another, rabbit hole to go down. But, we consent to these devices knowing where we are. When we use Uber, we want the devices to know where we are or where our children are. But how meaningful is that consent, in the sense that if we want to use the technology, we have to opt into it. So consent is no longer a meaningful concept. I think we have to move past the notion of consent in terms of understanding how data is used, is protected, who gets to use it, and I think we need to be very cynical about just things like, it's okay to use open data and de-identified data. I'm very cynical about that.
Well, the perfect example of that is you give the biometric data to DFAT to get a passport so you can go to another country, and that's the reason why you gave it. But it's going to be used by the various governments around the country for facial recognition. You never gave it for that purpose.
Well, I'd be curious to know if the Adelaide Law School is giving advice to students around the social media profiles and history, because that's been something for the last 5-10 years that employers actively use to vet the candidates. I know before I interview someone, I have a quick look just to see what comes up, just out of interest, and I'm pretty sure people are getting excluded from employment opportunities because of their digital trail.
So I think that the students are pretty savvy about that. I'm not quite sure that the staff have quite so I agree with you. I think that is something that students are certainly aware of. But even, I think, flipping it around the other way, how do they get jobs now? It's important, for example, to have a LinkedIn profile and to make sure that your photo, as you say, your photo on LinkedIn looks professional. It's not your sort of 21st photo or your one that was taken at school. So I think there's a lot of work, I think, that people now need to invest in maintaining their digital identity and their digital profile. And if they want to have a social life online that is a little bit more open, to be able to make sure that that's protected. So I think it's a really valuable point. Yeah.
Let's just move into the last topic, if we can, because I think it touches absolutely in this area and just opens it up really a little bit further, believe it or not. And this is this idea of algorithmic bias, or bias, and how that might impact the rule of law. So there's an interesting book. It's called Weapons of Math Destruction, by Harvard PhD graduate Cathy O'Neill, and she makes the point that algorithms are just opinions embedded in code. Rejects the idea that mathematics is objective, instead arguing that mathematical models serve to replicate biases and frequently reinforce discrimination. And if you want to know what she means, just take 20 seconds to Google the phrase 3 white teenagers and then have a look at the images that Google gives you when you put that phrase in, and then put the phrase 3 black teenagers in Google and then have a look at the images there.
Morry, what sort of ads I'd get after that.
Yeah. And somebody's tracking it too, for sure. But you know, this is the algorithm doing that, right? This is just an algorithm driving those results. And so the idea being that you know, algorithms are fed you know, training data, and that training data can already have some biases in it, and they reinforce those biases as the AI works. And of course, you know, algorithms in this space are being used already for decision making. We've touched upon it. You know, recidivism, failed decisions, criminal profiling, and I think there are mixed results there. I think, you know, proponents say that it takes out all of the subjective bias. Critics say that it's just you know, reinforcing what are already inherent kind of biases in the system. So we have a last question on that, which is kind of a big question, but it will give us a landing point about how. Oh, not that one, the next one, yes. How AI can potentially be a threat to human rights. So Darren, I'm going to go to you kind of first on this. Algorithmic bias or AI and human rights, what are your thoughts there?
I know Donald Trump is pretty upset at the moment about Google's algorithm. Apparently all he's getting is bad news. I think in any algorithm that's used to produce a decision, we have a policy, we have an opportunity to decide, is a human going to be in the loop or not? If the algorithm producing information is not the final decision maker, if you like, it's not a problem. It's effectively an opinion, and there's still a human in the loop. My father used to be a fingerprint expert, and in the old days we used to have to look for the right fingerprint through hard copy, and they brought the computers in, and you'd feed a finger in and it'd come up with 5 names. Well, Dad used to say that the computer didn't stand up in court, you know, he did. And so whatever algorithm we're using for any output, we must always take control and make sure that there is an active decision to remove the human from the final part of the loop, because otherwise, you know, you will get it wrong occasionally, and you can't, you know, blame the algorithm for that. It's how it's coded.
Morry?
I'm not sure I agree. So I understand that sometimes algorithms are better at working things out than humans are, but let me read these words of a sentencing judge in Wisconsin. You're identified through the Compass assessment as an individual who is at high risk to the community in terms of weighing the various factors on ruling out probation because of the seriousness of the crime and because of your history on supervision and the risk assessment tools that have been utilised suggest that you're extremely high risk to reoffend. That was Wisconsin, and I was reported in 2016. Neither the defendant nor the judge were given the opportunity to access the algorithm or the data from which it drew because it was trademarked. So the problem with algorithms when it comes to refusing bail, it's been used in the UK for police forces and so forth, for sentencing in the US, is the question of the bias of the people who create the algorithm in the first place. And if we have an inability to understand what's being put in, it's very difficult to rely on the information that comes out, even if there's a human in the process.
Thanks, Morry. Vanessa, I see you nodding to that comment.
Yeah. And I think the other thing we can't help, and it sort of gets back to the bot point. I mean, we can't help but interact with bots or AI as if they are human. So I know I was interacting with a bot the other day, and I was saying, "Oh, thank you," and that's great. I was like, you know, why am I doing that? It's so ingrained in us, and we assume that algorithms make decisions the same way that we do, but they don't. You know, so not only do we assume that they're lacking in bias, that they carry with them the sort of the authority of sort of being maths rather than a social science. So we sort of immediately elevate them to being sort of better than human decision making. But they don't make decisions the way we do. So we talk about, you know, correlations rather than causality. So with human decision making, you know, if this happens, then this intervenes, then look at these factors, then this could be the case. Whereas with algorithmic decision making, you say, you are like this, however this, you know, batch of decision making has been made. Therefore, because you are like this, this is likely to happen to you. So it's not even like the sort of AI decision making that was in, you know, the Tom Kruse movie, Minority Report.
Yeah.
You know, when that sort of made AI to be far more formed in terms of how people were going to action things. So
psychic children in the bathtub, ultimately.
yeah, that's right. It was human, so they were imagining how things happen. But there's some really, if you can just Google, you know, correlations, and I'll say something like, you know, there are more divorces in California by couples who eat butter than couples who eat margarine. You know, it's a meaningless correlation, but these are how decisions can be made.
Yeah, I shouldn't have had the butter. Luke, a final thought from you?
I agree with the comments made. I think it's important that these sort of tools, these algorithms are used as a tool to come to a final decision, not making the final decision itself. But if you're relying on that tool, like the example Morry gave, you need to understand how that output's being arrived at and what's been put in to get that output, so you can properly assess whether it's actually a useful indicator. So otherwise you can just see the potential for terrible outcomes.
Great, thank you. All right, so our question there to the audience obviously points to the fact that we do see the potential threat, but I think, you know, positives too are clearly part of that. LexisNexis, if you're interested, are working with the Human Rights Commission on a white paper, a paper and a policy in this space, which we thank you. Which I don't know, do we have any of these to give out, Max? We've given them all away, haven't we?
You can download the issues paper from the Human Rights Commission.
You can download the issues paper from the Human Rights Commission. We'll make sure we send that link to people if you're interested as a follow-up to. Thank you.
Simon?
Yes.
I just had a further thought about this, that we already have significant problems with speed cameras and how they're calibrated and, you know, hasn't been done properly, and what's working inside that black box to come up with the decision that you were speeding. How many quantum times more complicated will it be to want to delve inside the black box of an AI and try to subject that to cross-examination or dissection by a defence lawyer? It's magnitudes of orders more difficult, and I think it's almost intractable, quite frankly, and that's why I wouldn't even think we should begin to start talking about how that black box with this AI or this logic system is getting.
I understand that.
Because it might be a neural network. They're almost impossible to shortcut.
But what if the algorithm is designed by white people instead of some black people?
Which is why I think human is sustainable, because I'm not sure that we can unpack the algorithm sufficiently to determine whether it's well made, it's operating or coded properly. If there's human judgment at the end, then the decision that the algorithm is recommending becomes just that, a recommendation. If it's not binding, I'm less worried.
Okay, so let's open up the floor to questions now. We have 10 minutes before we will definitely come to a close. Tam's got a mic here. We have a gentleman at the front here who gave me an indication. He obviously either wanted to buy something or has a question. So,
I wanted to go back to the first question very quickly. The first question was, are grads well equipped to use emerging legal technologies like artificial intelligence? Is there a different question? Are grads well equipped to compete with emerging technologies like artificial intelligence, given many of the tasks that look like they're the first cabs off the rank are things like, discovery or due diligence, document review, that give young lawyers the opportunity to cut their teeth and sort of, be exposed to a range of things. If those tasks get automated away, where do the grads come in?
I've sort of slid on this one. So, if indeed we get to a point where artificial intelligence operates in a greater way, well, it won't be just graduate lawyers that are there. Other than that, I sort of lean to Luke's view of the world expressed a bit earlier, and that is, you get these completely catastrophic predictions in terms of its impact on future employment, and it could be that later this century some of that might come to be. There is a leading UK economist who talks about the productivity paradox, which is the fact that because there is greater opportunity in society for things to be done by machines, our productivity is maybe impacted. But I'm at least of the view at the moment that the types of, as long as we can use the technologies, what tends to happen is it wipes out not the graduate or the person who has to do it, but a process, and we tend to as humans, we just tend to lift ourselves up and be empowered by that process, as we have with other technology over the decades, and continue on.
So the reality is, I think that the discovery and due diligence type tasks, you're not really becoming a better lawyer doing that, you're just doing mindless work that the firm can bill for. So if that gets taken away, and it means that graduate lawyers coming through get to do more substantive legal work under supervision, I think that's a good thing.
Absolutely agree with that.
I agree with it as well. I think having spent months and months looking through folders of documents and trying to stay awake to find particular words, if AI can do that and do it accurately, then that's great. I think the other thing is we always say when a new technology that comes in, it's going to, people are going to lose their jobs. So but it doesn't happen that way. I mean, look at the paperless office that has emerged since we had the internet. It's been great now that we don't use paper anymore. So I think some of the things that it can do really, really well, some of the projects, for example, that Mark Castle's at the clinic, and I think she's working with the other clinics at the other universities with using some sort of AI for access to justice type projects, so bringing legal services to people who simply could not afford it, or assisting the courts with unrepresented litigants. So there's plenty of other things that bright young lawyers can be doing other than what I did, which was literally looking through folders of paper. So I think at that end of the spectrum, it's great. I think it couldn't be better news for young lawyers.
That said, there is, I don't know that I agree with the proposition that technology doesn't cost jobs, because what the 20th century did was take jobs out of manufacturing. The question here is, are jobs going to be taken out of professional services? Is that what the 21st century is about?
What we may see is less lawyers leaving the profession early because their souls have been destroyed through the drudgery of going through thousands of pages of documents, medical reports, looking for the 5 needles in the haystack that mention mental health, because you're not interested in all the ankle injuries. If that can be taken off, and the lawyer who's clearly gone through a lot of reading, got some intelligence, to do more productive things, that's got to be a good thing. The mythical man months will say that work will expand and the drudge work to disappear, bring it on, because we've got smart young lawyers who are leaving the profession early, in part I think because the work they're being asked to do is soul destroying and drudge work. The sooner that's gone, the better.
Any other questions from the floor?
Perhaps I can use the moment to say that last week the Law Council launched the Justice Project final reports about access to justice. One of the things about the consumer profile in Australia is that there are some consumers who just aren't using legal services at all because they can't access them. So the great opportunity that technology provides us is not at the cost of lawyers, because they're people who aren't seeking these services anyway because they can't afford them, is to enable people in a different way to understand their rights and entitlements.
Okay, yes sir.
Can I stop for sorry, is that me?
Yes.
Okay. Good, thank you. Can I stop for a counterpoint to the paperless office example that was given? And that is, It's not a lack of paper we see anymore, it's a lack of typewriters. And going back further in history, the population of horses in Western society, particularly in the US, has declined more than tenfold since we got the automobile. So I think the analogy is not the right one that's been made. Technology works in a different way to getting rid of paper. It's like saying we get rid of water or electricity, or we got rid of its typewriters.
Thank you for your comments, sir. Any other questions? Yes, lady in the back. Thank you.
So most of the sort of AI technology, most of the AI technology that's been talked about so far has mostly just been about sort of data processing and analysis. But there are technologies now that are looking to teach artificial empathy and to teach AI morals and ethics to factor in, as well as making just information-based decisions. So I was wondering what sort of impact this is looking to have to lawyers in the future, if that's something that should be concerning graduates and future students.
I think if my career has taught me anything, it's that empathy is not a necessary criteria to be a lawyer. Also, I'd say about ethics, ethics are just a set of rules that govern behaviour or how you undertake tasks, and that sounds very much like software code.
I think there are a number of projects that are going on about AI and ethics, and depending on which way you go, like putting the ethics into the AI, programming them in there, having them as legal requirements, or as you say, using the AI themselves. So there's the example of the roboticist that we had visiting Adelaide last year, that Bernadette will recall, about using robots, for example, to teach empathy or to look after elderly people, or people who are very difficult to monitor because they are very violent or have very difficult personalities. So there's all sorts of examples of where robots can be used, and when you say robots, you have AI because that's what's driving the robot in the first place. But I'm kind of a little bit disappointed that nobody actually brought up, say, for example, something like sex bots, and the ethical implications of that. Because I was pretty sure it was going to come up. So I'm just going to say it now, because I think this is our last chance, really, isn't it? So sex bots, obviously. So there's a whole issue there, for us to debate about what is that teaching us about human empathy. Is it good because it's providing, say, an outlet for people who otherwise may not empathise with a human being? Is it actually making people less empathetic? So I think we have a lot of work to do in this domain. And as I said, we look at robots and we interact with robots generally, and we can't help but interact with them as if they're human. We build them often to look human, but what if we build them not to look human? So I'm not answering your question. I'm just saying, yes, it's a really big question, and as a society, we're going to have to learn how we are going to negotiate that. And if we are going to, implement having robots that do jobs that are simply unsafe for human beings or that are unpalatable, where do we draw the line with how we treat those robots, and how we even treat things like sex bots that look like human? Are we going to allow them to be abused? Will there be, can you have a criminal offence against something that appears to be human, in the same way that you can commit an offence against someone, or you can have animated films, for example, that have been banned on the basis that they portray sex acts with a minor. There's no minor being harmed there, but is that creating a way of thinking about people? So I think we have a lot of work to do on that.
It's a question of the TV series Westworld, doesn't turn out very well.
Yeah.
It's a question to include ethics, because we have different views about different things. Ultimately, it's going to require statutory interventions.
Darren, do you have a final comment?
I just want to go back to the gentleman in the blue shirt who made a comment before about we used to have horses, and now we've got automobiles. And I think we need to be very careful that this can't simply be assumed that this innovation in AI is going to be just another technology. Since the Industrial Revolution, all the technology we've developed has replaced human labour and physical aspects to do things. Robots move faster. This is the very first technology that replaces not human labour and movement, but human thought. And that's fundamentally different. And we can't simply assume that the same rules will apply going forward. It simply can't be assumed that that's the case.
Thank you, Darren.
But it's very exciting at the same time.
Now, I did make a promise that we would finish on time, so I'm afraid I'm going to have to close the door there for questions. I know that some of you still have those. I would absolutely invite you to grab the panelists or grab me if you had a question. But obviously this area is an interesting one. I mean, in a industry or a space which, is all about the rule of law and transparency and equality and legal responsibility, this is always going to be. I'd just like to take a moment to thank our panelists, Melissa, Luke, Morry and Darren. Thank you so much. We will compile insights from this and from our survey that we also send out and provide that to everybody via email. I understand that the bar remains open, so if you'd like to stick around and have a drink and carry on this conversation, please do. But thank you very much. Thank you.
Thank you. Yeah, no, you're standing under the. I just started to feel it towards the end.
Thanks for the watching. Thanks.
Yes.